It's 8:30. Showtime.
And recording. Let's get into a little bit of Monday Night Law. And this is, of course, us. Thank you to those of you who already have contributed. Your contributions are greatly appreciated and are being put to very good use. So, again, I just want to say thank you for that. There's our street addresses. There's how you can send us direct through the bank if you wish, or PayPal, Cash App, either way. And now we're going to play around with a little bit. We're going to deep dive into fiduciary principles and practices. So I think this is a rather much needed topic because as far as what a lot of people perceive as when you hire somebody to do a job, right? Act on your behalf, right? So whether that is through a power of attorney or whether it is selling your house, it doesn't matter what it is, building your kitchen, cutting your hair, right? There's an implied fiduciary relationship in there, right? So they'd be professional, practitioner, and client. So let's go into, start up with what loss prevention is: a lawfully created LLC established to redevelop the clear distinction between Republican emoluments, bar monarchy emoluments, and Sharia entitlements.
Bar malarkey?
Right? Smew. Oh.
File 13.
So anyway, that's me. There's me, us, however you want to put that. We're still building some of the foundations for a lot of this stuff because some of it we are going to use, some of it we may not. So
there is that other one, that whole document that says something about being a registered trademark.
Oh yeah, I mean that one right there. So, yep, already got that covered. Anyway, so basically, judicially mandated to basically follow the letter of Florida law and the rules of the court in the event further proceedings are necessary. So, there's the mandate. There's a reason that judges grant standing to people who obviously know what the hell they're doing.
So. Take good notice of this mandate down here.
Mm-hmm.
Style. Christopher E. Hallett versus the Department of Revenue.
Right.
That's right.
So
the Department of Revenue was trying to say, "Oh no, we're the ones that are suing him," and no. The case style is him versus you, not you versus him.
Exactly, because we're going to explain why as we go along here and how all this stuff came into being. So hopefully you guys will kind of get a better understanding into exactly what it is that we do here and why we do it. And there is in the Constitution, and of course my oath of office, this word, right, which has been strategically left out of judicial precedent for more than a few moons now. Let's just put it that way for the sake of simplicity, right? So, but of all the words on this page, the most dangerous of these words is, I'll give you a hint, it's highlighted in red for a reason, right? So this is anytime you have an advantage over another person, any advantage, okay? Even doctors, hence the Hippocratic Oath, do no harm, right? So this is, again, anybody who's licensed, kind of one of those first fundamental principles you learn, right? Principles and practices. So here's the reason that we're doing this, right? Remember, SMU rolls downhill, not uphill. So when the kid's mother calls me and says, "Hey, the money that I'm supposed to be getting, I'm not getting. Why am I not getting it?" It's like, I don't know. Find out. Well, they won't let me find out. You have to find out. Well, why do I have to find out? Because you're the payor. Oh, shit. Okay, so you mean to tell me I have to go audit child support? Oh, crap. So this is one of those documents of my audit, right? So out of this one transaction, what is it? $1,512.88. This welfare state of Ohio got $1,179.86. And my kids got $333.02. Jump change, right? So, yeah, kind of needless to say, I was a little more than slightly miffed. So, and yes, of course, I provided medical insurance for them. There's the proof of that. You can verify that. Well, I don't even know. Is United Healthcare even still a thing now because of the keep your doctor shift made up? Anyway, I digress. So, anyway, when you're going to do something, you want to use your source materials, verifiable, right? Can you go to the shelf and pull that up and verify it? So, these are the two source materials that will be used in tonight's PowerPoint. So with fiduciary licensing, the agent-client expectation of performance within their fiduciary duty. So that's exactly what this thing is, right? That's how these things come into being, right? The law of their creation, right? You agreed to do something lawfully within the letter of the law. So anyway, so a fiduciary, what is that? Someone who is required to act for the benefit of another person on all matters within the scope of their relationship. One who owes to another the duties of good faith, loyalty, due care, and disclosure. The corporate officer is a fiduciary to the corporation. So that means as CEO, there's that relationship pretty much defined. Someone who must exercise a high standard of care in managing another's money or property. The beneficiary sued the fiduciary for investing in speculative securities. Yeah, we see this a lot. So this is what I mean when I say the things that establish what I cannot do in my person, I cannot do through the agency of another. Okay, so this is kind of the, I'll just call it what it is, sort of an opening statement, right, of what is required to do what I do. So the fiduciary duty is defined in the dictionary as a duty of utmost good faith, trust, confidence, and candor owed by a fiduciary, such as an agent or a trustee, to the beneficiary, such as the agent's principal or the beneficiaries of the trust. A duty of utmost good faith, trust, confidence, and candor owed by a fiduciary, such as a lawyer or corporate officer, to the beneficiary, such as a lawyer's client or shareholder. A duty to act with the highest degree of honesty and loyalty toward another person and in the best interest of the other person, right? Such as the duty that one partner owes to another. That would be like in what, a business partnership? So examples: directors have a duty not to engage in self-dealing to further their own personal interests rather than the interests of the corporation, also termed duty of loyalty, duty of fidelity, duty of faithful service, and duty to avoid conflicts of interest, which subsequently establishes this maxim of law that I use in contracts frequently. Always in doubtful cases, that is to be done by which a bona fide contract may be the safest condition, except when it has been drawn up clearly contrary to law. In other words, no, you can't write a contract to lie against somebody. No, you can't write a contract to go murder somebody. And no, you can't write a contract to go put a bounty on somebody's head. Jackwagons, you know who you are. So, In 1837, an agreement by which one party delivers something to another on condition that the second party will return the thing to the first. Okay. Goes with this legal this legal Latin principle from Roman law. A praetor's grant to a creditor of the debtor's entire estate as a form of execution of judgment. Okay. So this Latin principle, right? The person to whom, or I'm sorry, by, through, or through whom another has claimed something, or the person whose legal position is an issue. I have an issue with that fourth and fifth pillar of law in my republic. You get that crap out of here, right? So we have a fiduciary shield doctrine. What's this? In 1978, corporations, the principle that a corporate officer's act cannot be the basis for jurisdiction over the officer in an individual capacity. Well, guess what? They're exploiting this, which is why they use these corporations to do what they do, right? This is exploitation and misapplication of law. This is one of the reasons I know this stuff. I had to take a test on this stuff, believe it or not. AKA the doctrine of the corporate veil in the U.S. Code, 28 U.S.C. 1608 and 1330, as you've seen it on the cover page of my Weaponized Family Court Report. And it's this fundamental principle of law pretty much understands this, right? The law does not command useless things because useless labor is foolish. So now, this word principle, okay, remember, there's two spellings for this word. So dating back to the 13th century, as an adjective, this is the chief, primary, most important, right? Or if you're in high school, this is the spelling of your principal, right? The 14th century definition of a noun actually has with it 5 different definitions. So as a licensed fiduciary, I have to know all of these. Someone who authorizes another to act on his or her behalf. That's the agent, right? Noticed agent, noticed principal. Such as apparent principal, disclosed principal, partially disclosed principal, undisclosed principal, or unidentified principal, such as an heir to an estate not identified by name, right? So you see this a lot when there is heirs that, especially as of the last 15 to 20 years, who may have been adopted or whatever, and don't even understand or comprehend the fact that they are heir to a larger estate, potentially. So again, another word, the principal. Someone who commits or participates in a crime. Oh, principal in the first degree, principal in the second degree, right? That could be the trigger man in a bank robbery, not necessarily the getaway driver, but the trigger man. So principal definition number 3 is a noun, someone who has primary responsibility on an obligation, as opposed to a surety or endorser. Number 4, the corpus of an estate or trust. Somebody has to manage all that stuff, right? Better know that one. Of course, the 5th, the amount of a debt, investment, or other fund, not including interest, earnings, or profits. Principal action, see main demand, which of course we'll look into one of the ways of a disqualification. This is actually from Federal Rule 28C for disqualification. Now, a lot of you out there that are wanting to disqualify somebody, and it doesn't matter if it's an attorney, a judge, whoever, you can make reference to Federal Rule 28C if this provision does not apply in your state or local rules, right? Because the minimum is the, federal is the maximum, the highest level, the highest standard of law, but it is the minimum of due process. So as far as the court is concerned, even as well as in the Mason's Manual. So if this provision exists federally but doesn't exist in your state, you can under full faith and credit, utilize it. So a disposition must not be taken before a person who is any party's relative, employee, or attorney who is related to or employed by any party's attorney, or who has, or who is financially interested in the action, right? So this doesn't necessarily even have to be a transaction. It could be just an action. So this is what I said. This is principal and agent. Okay, principal and agent from the 17th century. The relation between two persons, one of whom, the principal, hires the other, the agent, that's me, whose tasks involve primarily the creation of new legal relations between the hirer and third persons. Hence the reason when Mama said, go find out what the hell's going on. Well, talk about a fiduciary relationship. I won't go into that one. This relationship is similar to that of a master servant, but that terminology applies to employments in which the employee has little or no discretion, whereas the agent has considerable latitude, right? Again, one of the benefits, right, that fourth pillar, I'm going to get into this real quick. That would be a potential benefit of being licensed in the first pillar, right? Being subject to, constant oversight, like I said, which is fine. So just don't screw up and break the law and you're good to go. Principle, again, from the 14th century, a basic rule or law or doctrine, especially one of the fundamental tenets of a system, right? This is Dad working all day long. This is the crap I had to go to school to learn how to do. We should follow our own rather than a foreign law. Would that be those foreign emoluments? So this is where we can get into, remember, Section 42, Chapter 7 of Principles of Parliamentary Practice. Section 42, there is an indispensable requirements for making valid group decisions, right? The law of creation of whatever it is we're creating, right? Certain fundamental principles govern decision-making procedure. These principles are so fundamental as to be required to give validity to the decisions of a group. These requirements generally apply without being adopted and without the consent or the approval of the body. These principles are stated in Section 43, which I'm going to go into here in a little bit. So, the procedural methods and rules used in a court of law, local practice requires that an extra copy of each motion be filed with the clerk, right? Some judges actually will request that you file an extra copy for them as well, for whatever the reason. Practice of law. Where is your practice, right? That's basically how it's defined. I almost shat myself. So, comes from this legal principle. The process of law is a heavy hardship. The execution of the law crowns or rewards the work. You've seen me use this legal maxim in several of my documents. So this again is part of that requirement. A person engaged in the practice of a profession, especially law or medicine, right? So you kind of have to know these 10 fundamental principles, right? If you're going to be licensed in anything. I would certainly hope so, because they're on the test. So, and the courts even recognize this under the Section 73, powers of the courts over legislative bodies generally. The people of each state are vested with sovereign authority expressed by their elected representatives serving in a legislature. Thus, a legislative power is absolute and unlimited, except as restrained by Constitution. So, again, you can't alter the fundamental law or the fundamental government style and form of government. And, of course, Section 16, fraud will invalidate acts, and we've been through this a few dozen times. but I like to make sure that I bring it back up because these cases in context, right? That's why when I scan these pages, I include the cases for you guys because, you know, many of these congressional members who are in fact bar members, well, we already know this stuff's been tested. Here's where you can go verify that. You don't need to ask me for that. You don't need to ask anybody for that. It's already done. So, and of course, we've defined what fraud is, right? We went down through and did that in the last PowerPoint. So, such a thing as a reckless misrepresentation made without justified belief. This is definition 2, by the way. In its truth, to induce another person to act. Okay. This stuff is on the test, right? You know, I didn't write this stuff. So let's get in and talk a little bit about bad faith since we've already talked about fraud. So it's not dissimilar. I mean, it's very similar to fraud, but dishonesty of belief, purpose, or motive. This is one of the reasons why you've heard many congressional members say, what's their motive for coming to me? A lawyer filed a pleading, or filed the pleading in bad faith, also termed fetus? Yeah, or fitus. So this you can go down through and explain a complaint catalog of types of bad faith is impossible, but the following types are among those which have been recognized in judicial decisions. So this is evasion of the spirit of the bargain, right? Lack of diligence and slacking off, willful rendering of imperfect information, abuse of power to specify terms, and interference with or failure to cooperate in the other party's performance, right? So let's see here. Restatement, second, of contracts, subsection 205 of public law. So, and of course, in insurance, which, you know, I won't go into insurance because anybody who has any insurance claims, you can screenshot that. But we see this a lot with bad faith insurance claims. Somebody claiming, oh, yeah, they hit my car. Yeah, BS, they hit your car. Bad faith denial. This is one that a lot of people misconstrue, that they think, oh, my case was dismissed, that must be fraud. No, not necessarily. That could be a bad faith denial, which is a denial made dishonestly, unreasonably, or without grounds, right? So you go and you say, look, what part of statement of claim in my brief do you not comprehend, dude? Right?
Mm-hmm.
Well, if you're dismissed anyway, and even if you have followed your due process through the remonstrance, right? So that dismissal can be overturned in the legislature as bad faith denial. So I hope that kind of answers that with, you know, orders denying due process, because, you know, denial doesn't necessarily constitute fraud, but it can constitute bad faith, and we can find that right here in the dictionary. Excuse me. Bad faith enforcement, which is something different, with the first with relating to patents, right? And I'm going to skip over the patent side of this, but in an infringement action, a counterclaim alleging that at the time of filing suit, the patentee knew that the accused product or process did not infringe, or that the patent was invalid or unenforceable, right? So there's an example of bad faith enforcement, such as a counterclaim or bad faith enforcement arises under Section 2 of the Sherman Act, right? Keep that one in mind. And under the common law of unfair competition, right? So why? Because a lot of this stuff is in the Commerce Clause, right? They're claiming I have a contract. Well, if your contract was written Contrary to the law, you sure as hell don't. So, bad faith filing. This is usually due to bankruptcy. Another reason I put this here was because I was going to delete it, but now that I understand why she put it in here, it was, well, bad faith filing doesn't necessarily constitute somebody filing a case against you in bad faith. This is actually geared more towards a bankruptcy claim, right? So when some idiot bar member says, "Oh, that's a bad faith filing," and your case has nothing to do with bankruptcy, you can say to them, "Dude, you need to go back to the dictionary and look up the definition of bad faith filing, because that has nothing to do with what we're talking about right here," right? So, and of course, badge of fraud, another one that is very commonly misapplied and misconstrued. This is a circumstance generally considered by courts as an indicator that a party to a transaction intended to hinder or defraud the other party, such as a transfer in anticipation of litigation, a transaction outside the usual course of business, or a false statement. Oh, there we go. An indication of fraudulent intent. So, knowing and understanding why there's so many of these things that are very commonly mischaracterized, especially by bar members, because they're not taught this stuff. We're taught it. My question is, why the hell aren't they taught it? So, Kangaroo Court, this one pretty much speaks for itself. I'm going to leave that up there so you guys can screenshot that. I'm not going to read through the whole thing, but basically, number 3 pretty much applies. A sham legal proceeding, right? I mean, let's just call it what it is. Shift made up, right? It's a sham. It's crap. It's garbage, right? What is a sham? A false pretense or fraudulent show, an impostor, something that is not what it seems, a counterfeit. That's what a bar card is. It's a counterfeit. It's shift made up. It's not Republican in character and form. Someone who pretends to be something that he or she is not, a faker. That's exactly what every friggin' bar member is. They're a faker. They're a sham. Shift made up.
It's a fraud.
I digress.
Scam artist.
That's a private membership only club. Anybody who tells you otherwise is full of crap. So let's look into sham action again. Another very commonly mischaracterized usage of this particular definition, okay? An objectively baseless lawsuit, the primary purpose of which is to hinder or interfere with a competitor's business relationships. See Professional Real Estate Investors Incorporated versus Columbia Pictures. And of course, also termed sham lawsuit, sham suit, also see sham exception. So, when you're transacting business, right, transferring property from person to person, entity to entity, this is all kind of stuff you have to know how to watch for it. So if you don't know what you're looking for, you're not trained in it, then how can you be effective as a fiduciary, right? So you see what I'm saying? This is one of those reasons why it's like, well, how is it that I hold these guys to my high standard? Well, here, let me show you what my high standard is, and you be the judge. So what is avoidable process? That is a defective process with a curable defect. I don't know if this is necessarily curable based on the fact that this crap's been going on so long, but I digress. A void process, again, this goes back to the 18th century, which is legal process that is in some material way does not comply with the required form. Okay, so again, you go back to and you look at the law of creation as it's dictated in the Mason's Manual. So if I can't even make a rule to do that, how the hell are you? How the hell is there any law, legislation, statute, code, word salad, protocol? Who the hell made that up? That's garbage. It's crap. Get rid of it.
Mm-hmm.
And of course, you're going to see a lot of reference in the dictionary with respect to patenting and patents, because you're talking about specific, what's called intellectual property. So if you want to research patents and you're getting into that, you may want to go into intellectual property rights. So, of course, process is a statutory category of patentable invention. So, you know, again, when you're talking about you can't license the practice of law, right? You can't patent the practice of law. How many times do the high courts need to tell you idiot bar members? Quit going around telling people that you're something that you're not. Your bar card is as fake as the car in the suit on your back. You don't own any of that shit. The bank owns it.
What's
Don't
that
tell
one?
me that that's not true.
What's that one you keep saying? My library card's got more standing in law than that bar card does?
Got that right. So let's look at a little bit here at void ab initio, right? Because when we talk about Section 16, how to void something, well, knowing the definitions of how to do that, you know, it's one thing to know the theory; it's something else to know how to implement it in practice. So, void ab initio is null from the beginning, as from the first moment when a contract is entered into. A contract is void ab initio if it seriously offends law or public policy, in contrast to a contract that is merely voidable at the election of one party to the contract. That's void ab initio. That's the proper application when they go in and say, well, I have this order. Well, that order is void ab initio because the mechanism that created that order is repugnant to the law. So you see what I'm saying? This is the proper application of making that argument. So, and of course, we know what the construct of the republic is in capitalism, right? Market margin and capital on the outside. We support the republic, right? Remember, go back to Annals of America. I went through on the Veterans Day show. I went through all the history of that. So through our market margin and capital, we manage those advantages, profits, and gains, right? So that's where our standing is, right? Our job as corporate officers is to manage this mechanism and make darn sure that it does exactly what it's supposed to do as characterized in law. Because if it's not, Houston, we got a problem. So pull this back up again. Now, remember, the 15th century definition has these three characteristics: advantage, profit, and gain. The 13th century carries with it four, right? Four pillars: profit, gain, advantage, and benefit. Bill Barr talked about this. Remember when he said the king used to hold all the cards? This is exactly what he's talking about. He held all the profits, all the gains, all the advantages, and all the benefits. So this is one of the reasons when we're starting to see this monarchical characteristic coming out in these arrogant fifth pillar actors. Well, I wonder where the hell they got that at.
Uh-oh.
Chapter 2. Uh-oh.
You cut out on us.
Shift made up.
Okay.
Can you hear me?
You're still there.
All right, cool. For whatever the reason, I don't know why. Oh, okay. Well, my mic says it's doing its
Good
job.
knowledge.
What's that?
Too much good knowledge.
Yeah, right. I think I blew up the internet. It's all your fault. I'll blame you.
Right.
So let me refresh my page here. Maybe that'll help. Constitutional provisions governing procedure, right? We go in and we were going to implement this. We already know our sovereign authority is established. We showed that. So we want to implement it, right? Somebody in a Congress, whether it was this one or whether it was a prior Congress, somehow, somewhere altered the fundamental law. which violates the law of its creation. So, you know, that's why I said the people that architected this are dead. What do you want me to do? Dig them up and kill them again? You know, hell, I was at work while all this crap was going on. So, you know, I was out busy running those market margin and capital while they were screwing around doing what they were doing. And of course, God, I bet you most of you guys know more about that than I do at this point. But anyway, I digress. So, this is where you go in and you implement in the legislative process where you have all the standing, right? And all you need to do is point out Section 6. You know, this process is controlled by constitutional provisions, and I'm the one with the sovereign authority here. So anybody tells you something other than that is lying to you. So I'm going to show you where I can verify that. And of course, you show them that in the book. Section 7 is very important in this, and I've expanded on this because I know I've only shown this part in the past. So being organic in character, constitutional provisions stand on a higher plane than statutes and are mandatory. Constitutional provisions prescribing exact or exclusive time or methods for certain acts are mandatory and must be complied with. Constitutional provisions that are general in nature and not exclusive may be directory, okay? Such as the difference between one statute says the car is yellow, the other one says the car is yellow with 4 tires. Well, if it's yellow with 4 tires, then that's the one we're going to go with. So examples of a directory provision are given below. So that's actually the next page, by the way. Here they are. Remember, you heard this here first, ladies and gents, because I've never shown this section of the book. Where there is no constitutional provision requiring that a legislature read a bill on 3 separate days, a law to that effect is directory only, and an act passed without complying with the statute is not invalidated thereby. So, you know, for example, do we need to read it into the record 3 days that the weather report says on this day it rained and we had a hurricane? And no, because we already know that the funds that are going to be directed to that hurricane cleanup are directory only. So you see what I'm saying? There's methodology behind a lot of this, and there's a proper way to use it. It's the proper way to use it is where I have a problem. So a provision for recording the yeas and nays on the passage of a bill may be directory only and not mandatory. So in other words, are we going to do it electronically? Are we going to do it on paper? How are we going to do this, right? If Congress or a state legislature violates a constitutional requirement, the courts will declare its enactment void. So when you go in and say, Congress, somebody made this shit up how many years ago, and I don't care how many years ago it was, you're gonna legislate this thing out of existence. And if they tell you no, now you can go to the high court and say, well, here's my petition of remonstrance where I specifically stated the claim. Here's the thing I'm grieving against. And they're not going to do it. You can go right to Section 7, number 2, and say, now you have a duty. It is within scope and authority of the emoluments of your office to do it. See what I'm saying? This is where applying the word in context becomes very key and critical. So under a state constitution, unlike the U.S. Constitution, legislation is not prohibited and may be allowed. Okay, so, you know, for example, well, who's participating in the quorum? Well, okay, because this is not the only people who are subject to that business are the ones who participated in the quorum. So you see what I'm saying? State constitutional provisions are not grants of power, but instead are limitations on otherwise plenary power of the people of a state exercised through its legislature. A legislature may enact any laws that that state or federal constitutions do not prohibit. So if you can find something that is in a different state's constitution that is not in your state's constitution, you can apply it under the full faith and credit clause, right, of the U.S. Constitution. So, and of course, there are examples of that in this list of cases. You can read down through them and go, holy crap, there it is. So, don't take my word for it. Go verify it. This principle comes from this quote, Democracy in America, okay, from like 1840. Again, this was something that was known clear back in the 1800s of what the dangers of a quote unquote professional practice of law would look like. So lawyers in the United States form a power that envelops into society as a whole, penetrates into each of the classes that compose it, works in secret, acts constantly on it without its knowing, and in the end models it to its own desires. What the hell does that look like? Okay, well, I was asked to expand on this a little bit. Remember, in the 13th century definition of the word emolumentum, there are 4 pillars there: red, green, blue, and black. You see those as I've got them right next to entitlement programs, right up here, right? There's your 4 pillars, right? This is why bar card carrying members serving in any other office or emolument is repugnant to our form of government, right? Period. Can verify that. That 4th pillar, that benefit, that emolumentum card, right? Because it's outside of our form of government. I can't go to the legislature or any licensing department and say, I want to look up the law offices of Dewey, Cheatham, and Howe. Oh, you have to go to the bar to do that. Oh, so then they have no standing in law. Yeah, no, technically they don't. Okay, all right. So going back to the most dangerous word here, advantages. Okay, we already know that. We've already covered that. The 5-pillar construction, that multitude of new offices, right? So the benefits that come from the entitlement programs that pay these officers to do this crap, right? This is how a perpetuity is constructed and managed outside of the scope and authority, or supposedly outside the scope and authority of the Republic. Hence the difference between the Republicans and the Democrats, right? And the Democrats have been historically using disadvantaged people to advance their political agenda. Don't take my word for it. Go verify it. And pretty much almost every piece of legislation ever presented by a Democrat. So that said, this is that design, right? Those malicious designs of men must be thwarted. This is exactly what that malicious design would look like. The difference between the 3 pillars of the Republic, advantage, profit, and gain, right? And there's the tie-in, because they're managing all of those with that benefit through those entitlement programs. So I hope this better clarifies for the congressional members specifically who had requested that I do this, by the way. So, because I understand there's a lot of confusion about this, right? Where the heck does the kangaroo court apply, for example? Well, between the 4th pillar emolumentum and the 5th pillar of Sharia law, right? That's why there's, around the negative nexus, there's those brackets, right? The parentheses signify the first, what needs to be done first, right? Parentheses, exponents, multiplication, division, addition, subtraction.
Please. Wow, this is a new one. I haven't seen this one. When did you do this one?
I just created this, and this is actually a surprise.
I was gonna say, come on, man. You keep creating all these different diagrams here, and I'm like, oh, wait a minute.
This one was the reason I was requested to do this was because, again, they're like, well, where does that benefit apply? We know you've got the word stipend, right? That Bill Barr answered the question. That's right there. Whoops. That's right there, right? So it's like, okay, well, that stipend is a benefit. Well, where does that fit? You didn't put it in the model. Ah, okay, I can do that. No problem. So And the reason I used green to outline all of these is because this is the money trail, right? This is where those profit emoluments, gain emoluments are, literally,
All the
this is
money.
why, yeah, that's why, it appears they're drinking from a friggin' fire hose. They are drinking from a friggin' fire hose. It is what it is. So, that's why I originally based this on two fundamental legal maxims, principles of law. It is a curse construction that corrupts the text, because this is a perpetuity, right? And one of my cases in the Texas case says perpetuities and monopolies are contrary to the genius of a free government. Oh, are you sure about that? Do I have to go back and read that again? So, reading means reading here. What is illegal ought not be entered under the pretext of legality. So how the hell did you enter this knowing that it is completely repugnant to the Texas Constitution, dude? What the hell are you doing? So so it was saying, look, yes, we already know this thing defies the law of its creation. Okay, so hence the reason when I entered this in with my credentials into the Florida Supreme Court, they're like, oh, thank you, God, somebody's finally coming out. Somebody grew a pair. Okay, well, yeah, I can certainly do that. So, that's why I said this was just one of those deals. This was kind of a surprise for you guys, because I was requested to do this by more than one legislative office. So, that's why I said, so this way, when I post this out there, this will answer the question of where the 13th century emolumentum and bar card played a role, right?
Yep.
We don't have kings here. So, hence those mini monarchies that are, these offices in every state. This is exactly what he was talking about, right? Mm-hmm. So, hence the reason when we came out and, of course, filed the grievance against Obamacare and Title IV during his, during one of those oversight hearings that they held him in contempt over, he said, I'm not defending Obamacare anymore. That was the fire under their ass that, yeah, and he's not defending Title IV anymore either. Mm-hmm. So, again, this I have some cases that I need to handle with specifically related to that. Go ahead.
Wanted to point something out here, 13C for emoluments.
13th century.
That's 13th century. The word emoluments has been around for a while. It's not like they shouldn't know about this, and I'm pretty sure they were taught about it in law school, maybe.
You would think so. I mean, don't you think they would have at least glazed over the Constitution? Right? Here's the other thing. The word emolument doesn't appear on my bar card. I don't know if it does on theirs or anybody else's out there. But I looked at mine and it's not there. It's on my oath of office on my wall, but it's not on my card. Right. So that's why I said it's got no standing in or at law. What the hell is this thing? It's crap. It's garbage. So, that's just a confirmation that I am who I say I am. Well, I can tell you right now, any identification carries with it all pertinent information. And I think what the emoluments of your office are, you'd want that on there, right? Because you'd want to be able to say, yes, I'm here, I can act, right? In the, to the emoluments of my office. I would certainly think if you know what the hell you're doing, you would want that in clear and plain language.
Well, this also goes into, due process of law and in instructing our representatives to perform specific duties. It would behoove us to actually go to the ones that have the power to do that.
Right.
Like going and telling on bad actors. We have to go to the legislature for that.
That's right.
We don't go to the judicial to tell on bad actors.
That's right.
But this is the scheme, scam, and fraud by the bar, who's taken over our entire form of government, right? Oh, you go to the Judicial Accountability Board if you got a complaint or grievance with a bad judge. And you go to the bar commission and you file a complaint with the bar if you got a complaint against a grievance against a bar member.
Well, again, that's a jurisdiction foreign to our form of government and unacknowledged by our laws, right? Which is why when I went to the licensing bureau and said, I want to see the licenses, bar cards for Dewey, Cheatham, and Howe, or whoever the hell it was I was inquiring about, right? Every one of us have heard, well, we don't have such a thing. Oh, so that means that's shift made up. Oh, awesome sauce. Moving on, so let's go into U.S. Constitution, Article 3, Section 3, since we're going to be speaking about the judiciary anyway. As this article is presented in the Constitution, does the court have subject matter jurisdiction to hear cases of alleged treason, even though the punishment for this crime is to be decided in Congress, whereas Title IV et al. Clearly defies the law of its creation? Right? So without going into reading all of Article 3, but I did scan it, or she did scan it, and put it in here so you guys could screenshot it and read exactly what the scope and authority of a judicial emolument really is as far as the Constitution is concerned, right? Before, of course, canon law, right? But this is the construction of the emoluments of the office, the chair, the seat they sit in, right? So now let's go to Section 3. So I want to concentrate on this just a little bit. Section 3 under Article 3, again, where the judiciary is. Treason against the United States shall consist only of levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act, or on confession in open court. This is the reason that they're specifically trying to flush the evidence, right? You go in, you make your record, and what's the first thing they do? Denied. And then they motion to strike, right? And get that off the record. See, this is why I go in or electronically file, because the system prompts me with a filing transaction number. So even if they strike it off the record, I still have the record of the transaction. So, too bad, so sad, you're screwed. So this is just me knowing how to do business. So now is defined in the dictionary, right? Further back in the actual dictionary definition with constitutional law, it's been defined as the constitutional provision defining treason as or against the United States as levying war against them or in adhering to their enemies, giving them aid and comfort, as well as empowering Congress to declare the punishment for treason. Ah, okay. Well, that's why I said this presents a question. I've never asked the court to go in as either in my personal or in my official capacity. Do you have subject matter jurisdiction over treason? So,
say that again.
Do you have subject matter jurisdiction over treason with this specific set of actors? Who the hell knows? I've never asked the question. Have you?
Who does?
Ah, there you go. Right.
Wouldn't that be the military?
That could be found where? Oh, let me look. Let's go back up to, what was it? Section 2.
Article 2.
Or no, Article 3, Section 2. The judiciary powers shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority, to all cases affecting ambassadors and other public ministers and consuls, to all cases of admiralty and maritime jurisdictions. Oh, well, they're acting in the Commerce Clause. That means they're acting in commerce. Is that, or is that not potentially maritime jurisdiction, admiralty and maritime? So, you know, again, that's why I said, does this go to the JAG court? Will this be handled in a court? I've never asked, right? So, you know, again, because this question is henceforth coming, I digress.
So, you know, I don't know that particular part there. I like to break it down a little bit different there, because it shows exactly what power is vested to who and where.
Right.
And not only that, it's a limitation. Because remember, what's that first fundamental principle of group decision making? You must have jurisdiction.
That's right.
Okay.
So like we've said,
doesn't the Constitution limit the federal government to what? Admiralty and maritime jurisdiction.
Right. So again, and to protect us against all enemies, foreign and domestic. So,
but that's admiralty.
Well, and again, it could be potentially domestic enemies. Is that still admiralty?
Yes, it is.
I don't know. What does Article 4, Section 4 call that? Domestic violence, right? So we've said, because it's domestic violence, as it's written in the context of the letter of the law, where does the trial happen? Because the word judge, or the word or the language that would grant subject matter jurisdiction of domestic violence to a court is not, the word judiciary is not even mentioned in Article 4, Section 4. So, right, that implicates that trial has to happen in Congress, right? You have to be impeached, removed from duty, and then the trial by jury happens in the Senate. Or did I miss something? Right?
Right. Should be.
Which again presents the question is gonna go before Judge Cohen. Does the court have subject matter jurisdiction to hear cases on treason? I don't know, because due process of law says domestic violence, which is domestic insurrection, domestic enemies within our country, their due process is provided in Congress, right? So, I don't object to that, but we're going to do it, and we're going to do it right. So what would the court's opinion be as to why you do or do not have subject matter jurisdiction over allegations of treason, right? So, and I will take this opinion to the legislature and enter it into the quorum. So, again, I don't object to the Article 3 judges entering an opinion as to why they don't have subject matter jurisdiction, because, again, extend full faith and credit. We have to follow the letter of the law, right? Well, the letter of the law stipulates, well, if the punishment is going to be dictated in Congress, why wouldn't the trial happen there as well?
What?
Right. And
I thought treason was a capital offense.
It is. But again, that's why I said the one of the main questions is, and I've been through many cases, and the standard which I have read is that allegations of treason are to be heard in the legislature, which of course I totally agree with that, right? Hence the reason I took my grievance to the legislature and entered the quorum. So,
right.
And because these actors are using these weaponized courts, hence me calling them the crime scene, right? The high court in the state of Florida has said, no, there is no jurisdiction without further opinion from the appellate court. So again, does he want to prosecute Raul Rojas for just unauthorized practice of Sharia law? And we'll deal with the treason later on. But there's a maxim of law that states treason is the above all crimes, or exceeds all other crimes in punishment. So you see what I'm saying? Do we waste our time with prosecuting him for unauthorized practice of Sharia law? knowing that we're going to try him for treason in the U.S. in Congress anyway. Right? That's why I said, do we waste the court's docket time? I don't think we should. But again, that's why I said, you guys leave your suggestions in the comments. I'd love to hear them, because this is one of those processes. I've never had to go in and say Jack Wagon has committed treason, right, in a position of an emolument. So
to kind of break this little section down here, section 3, treason against the United States consists of a living war against them. That's internal insurrection. That's warring against the Constitution. That's domestic violence.
Right.
Or adhering to their enemies, giving them aid and comfort. Okay.
Right.
This is where we use the Declaration of Independence, and this is why I try to explain that the Declaration of Independence is really a list of declared acts of tyranny, which is tyrants.
Correct.
So in our form of government, some of the things they're doing, it's the characteristics and conduct that makes them our enemy.
Correct.
So
exactly.
when we have things like erecting a multitude of offices and sending hither swarms of officers like CPS workers, police officers, those are standing armies, or a multitude of offices, right, that have been erected unlawfully.
Right.
So that is giving aid to our enemy by erecting these offices and sending out there to harass our people and eat out our substance.
That's right. So again, when we talk about
trying to give it an example.
No, you're absolutely correct. I love the way you put that, because that's 100% accurate, by the way. Because remember, in your state's constitution, your governor is the chief law enforcement officer of your state, but the actual elected law enforcement officer is your county sheriff. So who the hell is this other jackwagon? And we see this a lot, especially here locally. There's a lot of bickering that goes back and forth between policy officers and constitutionally elected sheriff's offices, right? You don't see that on the news, but there's an understood rivalry in there, and there always has been, because there's a potential encroachment on the sheriff's turf.
There we go. Now here's the thing. Okay, let's go back to what? Leave It to Beaver. Okay. How many deputies did he have?
Just one.
Sure.
You talking about Leave It to Beaver or Andy Griffith?
Andy Griffith, pardon me. Leave It to Beaver, same thing.
Yeah, right. Same time period.
Right. Pardon me. So Andy Griffith, right? How many deputies did Andy Griffith have?
Just the one.
Just one.
Right.
Okay, so you saw right there on TV how it's supposed to be. Why do we have a multitude of sheriff's deputies? Because the way it's supposed to work in law and history of law is that the sheriff is supposed to do posse comitatus, right?
Right.
It's supposed to say, hey, we got a bad guy here. He got away. The reward's $500. Okay, how many people can I deputize to execute this $500 reward for this bounty, right?
Right.
Dead or alive, or make sure you bring him back alive, okay?
You are coming with me. Oh.
Right? So the sheriff will deputize for the posse 4 or 5 people, okay?
Right.
So they go, they get the guy, they bring the guy back, they get the $500 reward, they split it between the 5 of them, and they all go back to their family. They're not a sheriff's deputy. They don't stay on the payroll. They get paid for the services rendered, and they go back home.
Well, and again,
that's how that's supposed to work.
Well, that's the law of its creation, and you're absolutely correct.
Right.
However, right, as we have grown in populace, right? What if grandma is, if somebody's breaking into grandma's house and she picks up the phone? Do you want the sheriff to say, you're gonna have to wait a couple of hours because I got to call a guy to initiate a posse comitatus?
No. See, this is why we're all supposed to have the right to keep and bear arms, and that right shall not be infringed. You get somebody messing around on your property, you have the right to shoot them. Now,
Thank you. Thank
that's
you.
in
God,
accordance
I was
with the
hoping you
law.
would go
That's what the
there.
law says.
Mm-hmm.
Do I advocate that you do that? No. I do not advocate for violence ever.
Right.
But what we're talking about here is the law and the history of law.
Right.
So I'm not going to lie to you and tell you that, oh, you don't have the right to do that, because you do. I mean, I grew up in an era as a kid delivering newspapers and stuff like that, and I'd see signs all the time at that time. Hey, no trespassing. Violators will be shot.
Right.
Okay, it wasn't no big deal to see that sign on a regular basis
Oh, yeah.
in my neighborhood. But today, oh, no, you know.
That's politically incorrect. You can't do that.
Right.
So anyway, that's why I said, I mean, you know, because this question is coming up, right, frequently, I wanted to really touch base on this, because in the context of a licensed fiduciary, what I cannot do in my person, I cannot do through the agency of another, right? Who's going to be the one prosecuting this? Under what duty, right? As you said, it could be military duty, right? So that's why, you know, that's why I said it is what it is. So,
right.
You know, to go in and further expand on this, I'm just going to touch on these real quick since we spent a lot of time on it. Treason is the offense to overthrow the government of the state to which one owes allegiance, either by making war against the state or by materially supporting its enemies. Ooh, imagine that.
It's them damn enemas, I'm telling you.
Right? So again, you can screenshot these next 2 pages. I'm not going to go through this. The judgment of high treason was, until very lately, an exception to the merciful tenor of our judgments. The least offensive form, which is given in the book, is that the offender be carried back to the place from whence he came, and from thence to be drawn to the place of execution. And of course, it goes and explains all this stuff up. So this, of course, goes back to what, 1826. So it's going to seem very archaic when you read it. So don't be surprised on that. So again, goes on further. Sorry about the book not scanning it right. She was having trouble scanning that. So it is legible.
She didn't cut the pages out?
No, she did. Yeah, she's going to cut my dictionary up. Yeah. So, but she did her best. There was 2 of them there. They were one was trying to almost standing on the scanner. It was funny as hell. But anyway, that's why I said you guys can. Treason against the United States shall consist only in levying war against them or adhering to their enemies. Boy, we see this language a lot. Giving them aid and comfort. No person shall be convicted of treason unless testimony of 2 witnesses to the same overt act, which is exactly the language from the Constitution as we just read it. So, now let's get into what under English law, what is a treason felony? Okay, well, under English law, an act that shows an intention of committing treason unaccompanied by any further act to carry out that intention. This offense usually results in a life imprisonment rather than the death penalty. That's English law. Well, Scott law is the devising of the overthrow of the sovereign or successors. Well, my authority is sovereign. Somebody trying to overthrow my ass. Right? So the devising of the levying of war on the sovereign to compel a change of measures or counsels to intimidate Parliament or to induce a foreign invasion. Uh-oh. Under that definition, somebody's in some deep shift made up. But I digress, which is, of course, treasonable misdemeanor. That almost sounds like a friggin' oxymoron, doesn't it? Treasonable misdemeanor.
What the heck is that? You know what? That's some bar member putting that crap in there so they can save their bacon.
Right, that's what I was gonna say. It's like, how the hell are you even thinking
That's
this?
what it is.
Right?
I know I'm committing treasonous acts, and I don't want to be sentenced to death, so we'll say this. We'll make this shit made up that says well, that's a misdemeanor treason.
Right. Well, how is it a misdemeanor when it's listed under treason felony? Yeah. Oh God, that's why it's like, oh Lord.
Oh, but CF, doesn't that mean C also?
Yeah, right. So anyway, before we go, let's recap on the important points for anyone who may have missed them. So, do you know your standing? Okay. Affirmative defenses, where to find them? You know, court rules, legal dictionaries, this type of stuff. She thought this was important for me to review this, so it's okay. Is performance relevant to is a relevant question, and why? Well, after you just watched this video, if you said no before, you may want to rethink the answer to that question. So, can you articulate why? And who can or cannot participate and why? Right? See the rules of the quorums, page 331 of the Mason's Manual, or Federal Rule 28C, right under disqualifications, as I showed you guys in the video. So, Federal Rule 8C, these are those affirmative defenses: accord and satisfaction, arbitration and award, assumption of risk, contributory negligence, duress, estoppel, failure of consideration, fraud or bad faith, right? Illegality, injury by fellow servant, hence the reason why I say in my official or personal capacity. Which one are we talking? Because if I'm in my official capacity, that would be an injury by a fellow servant, would it not? So, of course, latches, license, which I just discovered, which I just totally went over for you guys, so you would know what that means. Payment,
License me?
right? Release, res judicata, double jeopardy, basically. Statute of frauds, statutes of limitations, and of course, waiver. And so I said these are things that I'm, like I said, it's stuff's on the test. It's under tort law. So, of course, as you know, this video has been brought to you by us in conjunction with our support staff. And I, of course, always like to say thank you to Tanya Davia for creating our Teespring stores. You guys would like a souvenir, t-shirt, coffee cup, handbag, beach towel, throw pillow, pair of sweatpants, sweatshirt. Like I said, got some new product lines there. Looks like there's a onesie. They threw in a onesie in there, which I didn't even notice until just like when I went to right here, this bottom one. So if you got a little one, you want to get your little one started off on the right foot, there's a onesie for them. And of course, I like my Keep Your Doctor coffee cup. This is the Obamacare shift made up. I made that one especially for the old man. So again, you guys like what we do, you want to help us out, help us continue to do this stuff, please by all means. You can send personal private donations to Kirk at 6477 West Fairview Avenue, Suite C, Boise, Idaho, 83705, or to myself here at 16062 Southwest 34 Court Road, Ocala, Florida, 34473. And there's PayPal and Cash App. For Kirk, I don't have a Cash App. I probably should do that. And that's one of those procrastination things for whatever the reason. I just haven't done it yet. And, hey, it is what it is. I'll eventually get there. Maybe, kind of, sort of, ish.
Slacker.
Yeah.
It's
I
not
need
like
a secretary, dude. I need a secretary, like really bad. Of course, after watching this video, we're going to be going, oh, hell no, don't you call me. No way. Not with all that crap. So I wouldn't blame you. So, I mean, it is what it is. So anyway, I hope you guys were able to benefit from that a little bit. And